5 o'clock. I don't see Mike Hayes. Mike, are you on here? Oh, there you are.
Yeah, you can't see me?
Yeah, now I can. Good.
Okay.
Good. I believe all of us are here. And in 1 minute, I'll call the meeting in order. It's 5 o'clock. Borrowed the gavel from the town, so Tremont Board of Appeals meeting is called to order. We'll do a roll call of the members of the board. I'm Joanne Harris, Bass Harbor. Mel?
Mel Atherton, Bass Harbor.
Rick?
I'm here.
That's Rick Cohn from, you're also in Bass Harbor, right, Rick?
No, I'm from Seal
Oh.
Cove.
Sorry, Seal Cove.
Okay.
Mike
Mike Hayes, Bass Harbor.
and Marcia.
Marcia Madeira Bernard.
So I have determined that 5 out of 5 certainly constitutes a quorum. I'm referring to page 5 of the Board of Appeals ordinance and the order in which we should do things. I'm supposed to give a statement of the case and read all correspondence and reports received. Since it's well beyond 1,200 pages, I'm certainly not going to do that, but I will say that we are here to hear the appeal by concerned Tremont residents of the Planning Board's decision of November 1st, 2021, approving the site plan of the Acadia Wilderness Lodge. And there are many documents, and we have had good amount of time to review them. The next item is to determine whether we have jurisdiction over this appeal. Does anybody on the board have any concern about that jurisdiction?
Madam Chair, I have a concern not about the board's jurisdiction over the case, but its jurisdiction to hear an appeal involving a particular issue. I don't know if this is the time to bring it up or not. It's something I think we ought to deal with very early in the proceeding, but I'm not sure when the appropriate time to break in is. So whenever you think it's the right time, I'd be happy to proceed with it.
Okay, Rick. James, would this be a good time for Rick to raise his concern?
Depends on what it is. Jurisdiction, you're talking about jurisdiction, so if he's got something related to jurisdiction, he should go ahead.
Rick, why don't you go ahead then?
Okay. When I started looking at this case, it was apparent that one of the issues that was explored before the planning board and decided by the planning board was whether or not these sites constituted individual residential units or whatever that phrase is, or not. The board decided that they didn't. And so the 40,000 foot area requirement didn't apply to them. It's an interesting issue. And I was a little taken aback when I first read Ms. Chow's letter brief, and she didn't refer to the issue, didn't raise it, didn't mention it. And I wasn't sure why not. And then when I read Mr. Hamilton's response and saw that he didn't mention it either, which was no surprise at that point, because if she didn't bring it up, no reason for him to. It occurred to me to wonder whether or not that issue, namely the residential unit issue, was before us or not. I don't know whether it was abandoned by Ms. Chow or reserved for the Superior Court if she ever got there, or what. But and I'm not asking her to reveal her strategies, but I think we all need to know whether or not we are expected to decide whether or not the planning board was correct about that issue. I'd like to know also if the answer is no, it's not before us. Is it preserved for the Superior Court? I don't need to know that, but I'd like to. But I think we all need to know. It occurs to me that, and this is just a suggestion, Madam Chair, that if we hear from Ms. Chow and Mr. Hamilton to see if they agree on the answer to my question. Everybody in the room may know the answer to this except me. I don't know. And see if there's an issue for us to decide or not. If they disagree, then of course we can rely on we can listen to Mr. Hamilton's advice. I'm sorry, that's my phone and I wish it weren't doing that.
Madam Chair.
Okay. Yes, James.
Yeah, in brief, the judge's concerns are a substantive matter, not a jurisdictional matter that will be taken up in the course of the appeal.
Okay, Mr. Collier, will you let me know when it's okay for me to bring it up again?
Sure.
Okay. Any other questions about jurisdiction? Seeing, hearing none. So now we need to decide if the applicant, that's concerned Tremont residents, have standing before this board. Does anybody have any concern that CTR does not have standing? Very well, they have standing. Next order of business is determine who the interested parties are, who we can expect to hear from tonight. I'm assuming Attorney Chow, Attorney Hamilton, any other interested parties?
Yeah, good evening. My name is Diane O'Connell. I'm here representing the Tremont Planning Board on this matter. You may or may not hear from me tonight, but I'm available if you do have some questions.
Thank you very much. Anybody else? Okay, excellent. Okay, before I turn this over to Attorney Chow, on behalf of the concerned Tremont residents, I want to make it clear, we have 7 arguments that have been made by CTR. One of those arguments has 2 parts. It's really 8 questions before this board. We hope to complete this hearing in a reasonable period of time. We will be fair in giving both sides ample, but not endless, opportunity to present their cases. I would ask everybody to be respectful, focused, and as brief as possible. James.
Madam Chair, if I may, a couple of procedural matters.
Sure.
The first one is, I think you should make sure that the appeal was timely and that the required notices were sent, or it was posted, or whatever you do.
Okay. So on the first question, was this appeal submitted in a timely fashion? I know we all agreed to some extensions because of the sheer volume of documents involved. But is there any issue, I'd look at Jesse in particular, as to timeliness and of public notification of this hearing?
No issues that I'm aware of.
Okay, the next thing is an application for appeal was submitted and the fees paid.
Yes.
Okay, and then the other thing you skipped over is 2 things. One is to summarize very briefly, I can do it if you want to, what the appeal is, and then just generally, I think it's better if I do it, it's very simple. And then after that, we'll ask about conflict of interest or bias. So with your permission, I'll give a brief summary.
Please.
So there's an appeal of an application for an approval for a campground under the land use ordinance and the site plan review ordinance for, I guess they call it glamp ground. It's a bunch of yurts and some other glamping units. I think there's 54, 55 of them in West Tremont. I think it's near Seal Cove. And it went on last year and wrapped up November 1st. And it's been appealed. That approval has been appealed by the concerned Tremont residents, who are mostly neighbors, represented by Ms. Chow. The applicant is represented by Greg Johnson, the engineer, as well as the attorney. The applicants are the Hopkins, Kenya, and her husband James, and the attorney is Mr. P. Andrew Hamilton of Aroostook County. That's all I have, Madam Chair, other than if you would ask if anybody has a conflict of interest or bias.
Thank you, James. Any member of the board believe they have a conflict of interest in hearing this case? Or what was the other terminology, James?
Bias.
Bias. They would not be able to render a impartial hearing of this and a decision at the end of it. All right, hearing none, seeing none. I think we're ready now.
Lastly, I hate to be Budinsky, but I just wonder if the board would like to talk very briefly about a time limit.
2 hours.
What was that?
I'd suggest 2-hour time limit for tonight's meeting.
All right, so Mel is suggesting 2 hours. Any other board member want to weigh in on that? Marcia?
I'd like to suggest that there be a time limit as to how long a person can speak, like 5 minutes or 3 minutes or 30 minutes, so that we can get in under 2 hours.
Okay. I'm hearing 2 hours is sort of the tolerance level. Mike, any thoughts?
I just want to live long enough to go through the entire hearing.
Okay.
I'm not sure that we should limit ourselves to 2 hours for a multi-million-dollar project review. If we can do it, good. But I don't think we should do a rush job if the attorneys need more time to present their positions and we need more time to talk about it.
Sure, but you can always continue to another night if you.
Sure.
All right, I'd like to suggest then that we see where we are at 7 p.m. And if we're close to closing, we'll go a little further. If we're nowhere close to closing, we'll revisit how we want to proceed. So given that, again, I just would ask that the attorneys stay focused, be respectful, and as brief as possible. You can see that the board, you will have our full attention. This board has been diligent in going through the mountains of documents, and we want to do the best by the town that we possibly can, and we just ask that you help us in that endeavor by, again, being focused and as brief as possible. So with that, I will turn it over to Attorney Chow.
Madam Chair,
Yes, James.
I'm using up my time limit. Last
No, you're
procedural,
past it at this point, James.
the
Yes,
last
James.
procedural matter I have is vis-a-vis some emails that you and I participated in with a couple of board members. And I was reading through the MMA manual today, and my recollection was refreshed about such emails. So at the very last possible minute this afternoon at about 4:45, I forwarded them to Mr. Hamilton and Ms. Chow, copying you, Greg, town manager, Benjamin Plant. I think that was everybody. There's 2 or 3 emails. There's nothing substantive. There's a couple of questions, procedural questions, and there's nothing different than what I would say if asked this evening, but I thought I'd mention that, and that within a couple of emails, we basically told the board members to stop sending emails because it wasn't appropriate. But I sent those out and the board members can have a look at those. I don't think it's anything all that important. I'm going to shut up.
I do have one question, and it's more a procedural one. My assumption is that we will allow the appellants to walk through and discuss their total brief to us. Okay, we will then have an opportunity to ask questions and clarifications there. And then the Attorney Hamilton will be given an opportunity. And then do we end up voting on each specific claim? Okay, all right.
We do.
That's really, I just wanted to know what the procedure was. Thank you.
We do, and we do it by roll call. Okay, anything else, James? Okay, Attorney General, please.
Thank you, Madam Chair, and thank you to all members of the Board of Appeals. I know this has been a long time coming. I really appreciate everyone's focus and attention to what is a very large record and many issues. On behalf of concerned Tremont residents, I would like to focus my remarks on the 7 or 8. I think, Madam Chair, you're correct that we're going to focus our attention on the 7 or 8 issues that we highlighted in our written submission from February 28th. And I also will incorporate those, the written submission into our remarks. And what I've done for today, which I believe Mr. Dunbar said would be okay, is I do have some slides that are intended to really streamline the presentation. Hopefully it does that so that we're not bumbling through the record, because we are looking at a record. We're at some odd 1,500 pages. And so I'm hoping to focus the remarks on these specific issues. So you'll see everything that I'm going to submit is either from the ordinance or the record. And so you'll see that in just a moment. So on behalf of CTR, what I would like to say, though, is that the standard of review here is whether or not the decision is clearly contrary to specific provisions of the ordinance. And if I could share screen, I see the green button, so bear with me. I don't see it. I may need some help finding it. Hang on just a moment.
I think the Zoom chair has to turn over permission to you to share your screen.
Has that happened? I don't
No.
know. That has.
It should be. Let me make sure. Yep, it should be working.
Apologize. Okay. I'm going to get some, I'm going to try to get some help, but let me just start right in with the background comments, and then we can get to the slides. So what I was saying was that the 8 points that we're going to be presenting tonight I think the Board of Appeals has to focus on what the standard of review is that's in front of you. And the Board of Appeals ordinance, as I mentioned, says that if the decision of the planning board is clearly contrary to specific provisions of the ordinance, or if it was not supported by substantial evidence in the record, then the Board of Appeals may reverse the decision of the planning board. And I will acknowledge that in this case, there is a voluminous record. And so you could say there is a great volume of evidence in the record. We certainly acknowledge that that is the case here. But I would say that the mistakes and errors made by the planning board here really fall into two categories. One is that they failed to make certain findings that were necessary to determine whether the standards for approval were met when they approved the project. So even though there might have been a volume of evidence, they didn't meet the standards. The second is the planning board in certain instances just improperly deferred satisfaction of those standards to a future date through the imposition of conditions of approval, which we believe was inappropriate, and did not, and in some cases delegated that authority to either a different body such as a code enforcement officer or to the applicant itself. And so as a result of those errors, the Board of Appeals, we believe, needs to reverse the decision. The reasons that I believe the planning board made these mistakes have to do, I think, with two contextual reasons. And one has to do with the fact that the planning board, although with a lot of volume of evidence, accelerated their review of this case. We all know that we had 5 or 6 hearing dates, and because the applicant insisted that review be completed by November 1st, which was the night before a moratorium vote in which voters voted to adopt a moratorium by a vote of 428 to 215, the process was condensed and accelerated, and which led to the certain standards essentially being deferred into the future. And then secondly, what happened was that the applicant claimed that a neighboring campground, which we are calling AWL1, which is the 1.6 acre parcel to the east, and immediately adjacent to AWL2, this particular proposal, that they alleged that this was a completely separate project at the same time that they had integrated it, and were not and didn't consider the fact that there were impacts from the AWL1 site to the AWL2 campground in their review. And the first place where you see that the most strongly, I'm going to try again, and I ask you to bear with me. Maybe I can get some help for some exhibits that show what may be going on here. Hang on just a second. Can you all see that document,
No.
Madam Chair?
No. Briefly,
What we see is a desktop. We did see a document. Oh, there it is.
I see a
Yes.
document.
Okay, apologize.
We're seeing the Board of Appeals standard of review.
Yes, I see that.
Thank you. Bear with me.
a power PDF, it's not a slide.
How do we
So
advance it?
just your pages are there, that paragraph.
Okay. All right. Technology is not my strength. Again, I apologize. Can everyone see this slide?
We are seeing AWL 2B site plan.
Okay, all right.
Yes,
All right, thank you very much. I just thought I'd show this background slide because this is what we are calling the AWL 2B site plan. The reason we call it 2B is that the original plan that came to you for 154 units, which included 70 some odd RVs, is what we are calling the AWL 2A site plan. But this shows the AWL 2B site plan. So what I would like to show is that the emergency access proposed in this proposal was to provide for access through the AWL1 site. And this is what you're seeing here with the arrow. And what the applicant failed to do, and we believe that was an error, is the applicant did not connect up the emergency exit so that there is no connection to any road at this point. This is where in the record that the applicant at page 623 of the record indicates that there will be an emergency only access for fire, ambulance, and police that will be provided off the east side of the site to Kellytown Road. And this is what we're talking about here, where you see the arrow. And it says that the applicants are partners in the adjacent 11-unit site, and the owners intend to remove the entrance from Kellytown Road and use the now Route 102 entrance once approved and constructed as the main access for users of the campground. And in that proposal, what you will see is that the connection of the emergency access road that was going to go through the AWL1 site, which is depicted here in yellow, does not actually connect to any road. The two rectangles that you see to the right here, this was the original site plan, the one bordered with yellow. And then the one next to it is the site plan amendment, which is the most recent site plan amendment that was, we believe, improperly authorized, but was authorized by the code enforcement officer in July of 2021. And in each of those cases, if you look at both of those plans, what you see is no connection. And this is a blow up that actually depicts this, I think, pretty clearly. So even though what we have here is the applicant proposing to connect up an emergency access route that would connect to the AWL1 site, there isn't actually a connection that was made. And so this was a fundamental error in the planning board approving this without actually approving a connection through the AWL1 site that would actually get out to Kellytown Road. And what I would say was that the failure to do that meant that it did not meet the land use ordinance or the site plan review ordinance requirements that the layout of the site must provide for the safe movement of emergency vehicles through the site, or that clear routes of access must be provided and maintained for emergency vehicles. So if someone were having a heart attack or if there were a fire, you would have no way to use this emergency access point to get it to Kellytown Road. It's like saying there's an approved fire door here, but it's nailed shut. And while the applicant might say, well, we'll take care of that later, but that's precisely the problem with the proposal. At a minimum, the planning board should have made the applicant approve this, if they were going to approve it, subject to a condition that they would get subsequent approval from the planning board to connect these two roads up. They have not yet done that. And at this point, the approval has an emergency access that goes to nowhere, which was a clear error of approving an emergency access route that does not connect to any road. The second issue that is part of the overall point that they didn't really integrate this proposal adequately and consider the fact that AWL1 impacts are going to impact the interior of the site of AWL2, which is before you. And this shows the applicant's own proposed internal vehicle circulation pattern. And if you can see the orange, the light orange shows that this round interior road goes clockwise, and it's a one-way road. Two-way traffic is only where it's red. So if you are thinking, which the applicants have admitted, that they are going to close off the entrance to Kellytown Road, and they are instead going to have AWL1 users use the interior road system of AWL2 to get to Route 102. And if they were to do that, AWL1 users, when they come in to Route 102, they would have to go all the way around clockwise before they get to the AWL1 site. What they should have done, or at least considered to do, is make this section of the road that's orange, that's most close to AWL1, a two-way road. They didn't design it that way because they never considered the impacts to the internal vehicle circulation pattern. They didn't consider the impacts of AWL1 drivers and users and patrons who would be using the AWL2 site. So on the one hand, they can't have it both ways and say these are two completely separate proposals, one that's been approved and one that is before you for approval, planning board, and then integrate them in such a way that there are impacts that they did not consider adequately in their traffic pattern approach on the AWL2 site. So those are points 1 and 2. Point three has to do with the failure of the applicant and the failure of the planning board to make the applicant delineate a northern property boundary, separating the campground development from the remainder of the site.
Excuse me. I'm wondering, the board mentioned, sorry to interrupt, but the board mentioned earlier that it was going to look at each issue separately.
Oh,
I want to know if the chair would like to stop here, hear from Mr. Hamilton, discuss it, decide on this issue. Chair, do you want to do it that way, or do you want to let Ms. Chow finish, do all of her things, seeing how she's got her presentation up? That's what you agreed to earlier, was to look at each one separately.
Well, we will have to decide each one separately, but I think I'd like to give Attorney Chow and then Attorney Hamilton their block of time.
All right, she's got her thing up. She's on a roll, so.
Yeah. Please continue.
okay, thank you very much. Again, the failure here was the failure to delineate the proper northern boundary line to the campground. You can see what I mean. Can you all see my cursor moving, or can you not see that?
We can see that. Yes.
Okay, good. So when I say northern property boundary, this is what I'm talking about, where the plus sign is moving. What you can see, what the applicant said when they presented their application from September 14th is that they would have retained open space in this northern section here, that they would agree to keep open for 5 years, but they anticipated that it might be developed in the future for residential development. They did agree that it would never be used for the campground. The campground development, the business commercial campground development, would be limited to roughly this half of the site. But what they didn't do is delineate where the edge of that development site would be. And the reason that's a violation of the ordinance, it's twofold. First of all, the site plan ordinance says that you need to delineate property lines that show the property to be developed. And while I would agree that this is not a property line in the case of a separate lot, it certainly is a boundary that's necessary to be demarcated, because your ordinance requires there to be a buffer separating out any vacant or residential properties from commercial uses. So your land use ordinance actually does require at Article 6A3 that buffers are required for commercial uses that abut residential or vacant properties in all zones that allow those uses. And now Mr. Hamilton said in his submission, and what you should see here is what was submitted to the DEP for purposes of determining whether or not this was subject to site location of development review. And I know that's not what the planning board was looking at. I know that's not what the Board of Appeals is looking at. But the reason this is significant is that Mr. Hamilton represented that they did indicate internally by a dashed line that this is where the line would be. But what you can see is there isn't such a line here. And in fact, if this is a line, this purple line, what it actually is it's not separating one half of the property to the other. It's actually just separating and going around the development area. And you can see that what they've indicated is that the developed area is 18.29 acres and the retained area is 24 acres, which would include all of this, what they would say, undeveloped land in here. And so far from creating a buffer, what it looks like the planning board did in not requiring this to be a survey line on the property line is it made the planning board an unwitting partner in AWL's attempts to evade site location of development review. There was no line placed here, and the error in not placing a line here was that your ordinance requires there to be a line showing where the commercial uses will actually border, that show that where the development will be, so that you can identify the appropriate buffer that needs to buffer all commercial uses from the open space. Now they may argue, well, this entire area to the north was going to be open space. Why can't that serve as a buffer? And the reason that can't serve as a buffer is, first, it wasn't designated as a buffer, but more importantly, they have only reserved that as open space for 5 years. So if they had said, we will conserve this land as open space in perpetuity, and we'll call that the buffer, that would be one thing. But they haven't done that, and this purple line I would submit falls far short of a 25-foot buffer that your land use ordinance requires in Article 6 of your land use ordinance. So this actually shows a blow up of the no buffer area. And so far from splitting off the northern area of this parcel from the rest of the area, this hashed line is not doing that. And it doesn't clearly separate. And it shows that that the applicant has been trying to evade site location of development review. So I'm now moving on and trying to keep fairly efficient here to, I don't know if this is my third or fourth point, but this is the issue of the other failure that was clearly contrary to the ordinance, was that the planning board failed to make the required finding that that this campground met the light commercial standard. And there was a lot of debate before the planning board as to whether light commercial is a standard and whether or not the planning board needed to make a finding that this campground this glamp ground as proposed, 55 unit glamp ground with a spa, with a dog park, with multiple amenities, a cafe, a restaurant, and employee housing, all of this, they needed to make a determination as to whether this was light commercial. You heard was a lot of testimony and a lot of public comment on urging the planning board to make that finding. Is this light commercial? We don't think so. We think it's heavy commercial. But you need to make a finding as to why this would constitute light commercial, because the impacts are significant on surrounding areas. And this zone is supposed to be for light commercial. The reason why it was an error for the planning board, not to determine whether this was light commercial is because your ordinance requires, under its townwide buffering standards, that if you have a use that is considered heavy commercial as opposed to light commercial, then buffers are required within the front property lines of those uses. And so without having made any finding at all as to whether this was light versus heavy commercial, and we would submit that it was certainly heavy commercial and required a buffer, the planning board didn't make any finding as to whether a buffer on the front property line of the property, meaning buffering the farmhouse cafe and the front area that borders Route 102. This was an error as well, because the planning board didn't even reach the question of whether or not a buffer was required on the front property line, because they didn't determine whether this was light commercial versus heavy commercial. They were advised by their attorney that the light commercial standard was not a standard and that they didn't need to make a finding that this was light commercial activity. And while light commercial activity is in the purpose section of the RB zone, we will acknowledge that. What I would say is that your ordinance does require you to make, or did require the planning board to make that distinction. And without having done that, they have not proposed a project that has any front line buffer. Moving on to the next issue. This is the groundwater protection standard for site plan approval, and quite a bit of time was spent at the planning board hearing regarding this standard and whether this was met. And we believe there were several significant problems with the way the planning board ultimately made its decision with respect to deciding that this standard had been met. And for purposes of our remarks tonight, I'd like to focus on the portion of the groundwater standard that goes to groundwater quality, meaning the quality of the groundwater as it is coming out of the leach field, so that it meets the state's safe drinking water standard at the property boundary line. So your ordinance says that the system has to demonstrate that the groundwater at the property line will comply following development with the standards for safe drinking water as established by the state of Maine. That's not what was done here. There were several problems with how the planning board resolved this issue. The first problem was that the only place in the application where, and when I speak about the application, I'm talking about the September 14th application. The only place in this application where groundwater quality and whether it was met at the property line was discussed. Discussed it in terms of whether or not the applicant could show that the leach fields were at least 300 feet away from any neighboring well that might be on or off the property. And what you see here, and you'll see leach field 1, 2, and 3, and you'll see these concentric circles. And the first problem with that, this is the only evidence that they submitted in their application to show that the groundwater from the leach fields would be safe to drink at the property line. The reason that standard that they used was inappropriate is that the issue is not whether the distance between a leach field and an existing well is, is more than 300 feet. The issue is that you have to have clean groundwater that's safe to drink at the property line so that abutting property owners are not impacted by this development. It doesn't matter if the abutting property owner doesn't yet have a well on their property. And so if you look at this figure, what you see, I'll just take this. This was testified that this was downgrading of the leach field. And you'll show that even if you use the 300-foot standard, and CTR's expert engineer hydrologist said that this was not an appropriate standard to use, but if you use it, it shows, it actually doesn't show that there's safe drinking water at the property boundary. And so that if the neighbor placed a well right here within this area, you wouldn't have any evidence that that this was safe drinking water at the property boundary. Just wanted to highlight the testimony of CTR's engineer, Matt Reynolds from Drumlin Environmental. And the first thing he says is this 300-foot wellhead protection standard is not the appropriate standard to use because it doesn't measure anything at the property boundary. And even if it did measure that, this standard, which is the sole standard that they used, isn't met at the property boundary. And Mr. Reynolds went on to say, I don't believe this is being used appropriately to show safe drinking water at the property boundary. I've not seen it used before. It's a different kind of standard altogether. And what is a much more common way to measure safe drinking water at the property line that is coming from groundwater from the leach field is to do a nitrate analysis. And that's what Mr. Reynolds said. So fast forward to a PowerPoint slide that Mr. Hamilton, the AWL's attorney, submitted on October 26th. What I will suggest to the board is that on October 15th, as early as October 15th, earlier than October 15th, I believe October 8th, early October, Mr. Reynolds had submitted a letter to the planning board and to the applicant that stated that they had not, there was no evidence in the record that the groundwater at the property boundary line had been met. And that the 300-foot standard was just not a standard that got to this issue. Then we get all the way to October 26th, and the first time we hear about any measurement of anything at the property line is this slide that was presented by Mr. Hamilton. And here is what he says about groundwater quality. He says the mass balance calculations show that the nitrate nitrogen concentrations are less than the US EPA maximum contaminant level, I think it's contaminant level, for drinking water of 10 milligrams per liter at the property line. And this is the statement that Mr. Hamilton cited in his pre-hearing submission to show that this standard had been met at the property line. And I will submit to you that there is simply no record evidence anywhere in this record for a mass balance calculation. And that Mr. Hamilton's representation in a PowerPoint slide presented to the planning board at the 11th hour is not evidence. There is no evidence in the record. There is no testimony that says that there is any mass balance calculation. And in fact, there are no mass balance calculations that were submitted as part of this application or at any time during the public hearing process. The only thing that occurred on that at the 11th hour was that Greg Johnston, the engineer for the project, did testify, and this was the extent of his testimony on the issue of groundwater quality. He says, related to groundwater quality, we're going to be facing a state permit that requires a term called transmissivity. That term is not in the ordinance. We have not submitted on that because it's like the hydrology question, but it's basically an evaluation of the nitrogen nitrates as they migrate from a leach field to a property line. In preparation for that application, both our offices and FGS offices evaluated the site using mass balance and groundwater flux models. Now that is the sum total of testimony. There's no calculation referenced. There's no evidence showing that a 10 milligram per liter nitrate threshold was met at the property line. This is the sum total of the evidence, if you want to call it evidence. And I would respectfully suggest that an 11th hour statement by the engineer that we're working on this and going to do this in the future does not meet the standard that the planning board had to say had been met at the time that they issued approval and not into the future. So another problem with this standard.
Michelle,
Yes.
if I may, you've had the floor for about 35 minutes. I'd like you to wind up, if you could, in the next 10.
Yes, I will. Thank you. I think I can do that in 10 minutes. Thank you, Madam Chair.
Thank you.
I'm still on the groundwater at the property line issue. And now I'm getting to the conditions of approval contained how the planning board dealt with the fact that there was no record evidence whatsoever showing that groundwater at the property line would be safe to drink. And our expert said a nitrate analysis would be a good idea. It's true that the standard doesn't say a nitrate analysis is required, but in this case, there was no evidence that went to that issue. And so what I will point out is that the site plan review ordinance says that it's the planning board's duty to determine whether the standards have been met. And only the planning board has exclusive authority to make sure that the groundwater at the property line standard has been met. But the final condition of approval actually delegated improperly that authority to the code enforcement officer and said that they must demonstrate to the code enforcement officer, who, if satisfied, will recommend and file with the planning board a demonstration that groundwater at the property line meets safe drinking water standards. I will submit to you that delegating that authority to the code enforcement officer to determine if he is satisfied that the groundwater at the property line standard has been met is an improper delegation of authority. And the fact that they are going to do future nitrate tests, or they say they're going to do that, doesn't mean that they have met the standard. And what I will say that's interesting is that in Mr. Hamilton's submission, he actually misstates what the final condition of approval is. And he states that the condition of approval showed that it must demonstrate to the code enforcement officer, who will make a recommendation to the planning board, that groundwater at the property line will be met. And that's not at all what the final condition of approval was. And the reason that's important is that in Mr. Hamilton's brief, and I won't go into the law in great detail, but he cites a case, Jakes versus City of Auburn, in his submission for the notion that you can take a condition, you can, instead of having the planning board determine that they've met a standard, they can kick the can down the road and let an expert decide that in the future, and that would be fine. And what I would submit to you is that the Jakes versus City of Auburn case says quite the opposite. In fact, the Jakes case supports our position. And what it said was, in that case, there was an odor issue at the property line standard. And in that case, the planning board said that the standard would likely be met, but they hired an expert to actually advise the planning board. The expert would actually help design a biofilter design and oversee the construction and provide ongoing advice and assistance to the planning board. In that situation, I would suggest the court is saying the planning board has retained jurisdiction over this issue. It hasn't abdicated it to an expert. In this case, the planning board abdicated its exclusive authority to determine groundwater at the property line is safe to drink to the code enforcement officer by claiming that, hey, we're just gonna have the code enforcement officer file it with the planning board. That was an error that was clearly contrary to the ordinance. I'm wrapping up here. I'll skip over this one just in the interest of time. I just wanted to point out that the planning board's own attorney did say that it's the planning board's decision, but ultimately that didn't happen, and that's not how that decision occurred. Moving on to a main argument about whether or not these applications are pending and which version of the ordinance should apply in this case. And I use this exhibit to show you what we call the two-way proposal, which has the RVs, which included development of the entire site. This was the application that was first submitted to the planning board in January of 2021. And this, there's no dispute, this plan was abandoned. And in its place, the AWL 2B proposal was first proposed, and a separate application was filed on September 14th to the planning board. And the planning board's attorney acknowledged that the changes in this new concept plan were significant enough to likely require a new completeness determination, a new completeness review by the planning board. Even Mr. Hamilton, the attorney for the applicant, suggested, recommended, and agreed that a new completeness determination was met, because we needed to have completely re-engineered plans and a new application. Whether you call it a new or revised application, this was a different enough plan that it required significant re-engineering and a new completeness determination before they would open it up for public hearing. So there's been a lot of discussion in the briefs about, the law says this about what's pending and what's not, and there are all these cases. I would submit, there's one MRSA 302. I would submit to you that it's very simple. Under the town of Tremont has made this issue and the resolution of this issue of what's pending and when it's pending in its own ordinance in reference to this one standard in Article 8D9. It says an application is pending only after it has been determined to be complete by the reviewing authority. I would submit to you, you don't need to go to 1 MRS 302. You don't need to go to any of the cases to determine that whatever application was submitted on September 14th needed to be determined to be complete before it was ready for hearing. And your ordinance clearly, the plain language of the ordinance says that application, whatever was submitted on the 14th, however you want to characterize it, is pending only after it's been determined to be complete, which was September 21st. So under the plain language of your ordinance, I would submit the May 5th amendments do apply to this application, and the planning board committed significant error, clear error, by failing to apply the May 5th campground amendments to this application. Why is that relevant? And how did they violate the ordinance? The May 5th amendments impose a 50-foot setback to most structures and accessory uses to campgrounds, and utilities as well. And in one area right here, what you'll see is this yellow line represents the 50-foot setback. And it's undisputable that this leach field encroaches upon the 50-foot setback. That's a clear error. They didn't apply the 50-foot setback. The planning board did not do that, and that was clear error. Secondly, remember that all structures have to be set back 50 feet. The farmhouse structure that's going to become the restaurant needed to be 50 feet back from the road. And as you can see here, it violates that setback. Now, Mr. Hamilton may argue, well, there's a whole bunch of rules that talk about setbacks for structures that have already been on the ground. And admittedly, this makes this a non-conforming structure. But the rules on non-conforming structures are as follows, and I have this on this slide. This is a non-conforming structure And if you change the use of a non-conforming structure, this is a farmhouse that used to be used residentially. It's being proposed now to be used as an accessory restaurant cafe use for 20 seats. And the planning board needed, before they authorized this, needed to have determined that the new use would have no greater adverse impact on the subject or adjacent properties and resources than the existing use. I would submit to you that a restaurant associated with a campground, it would be difficult to say that there isn't any greater adverse impact than a residence that a restaurant would have. So that was another clear error that the planning board made. Finally, on this one issue is that there is a standard that says, hey, you don't have to comply with your setbacks if your farmhouse structure has been on the ground since 1994. There's no dispute. This is an 1880s residence. It's been on the ground. But what it says, what the ordinance goes on to say is that you can forget about setbacks. You can forget about the 50-foot setback as long as the buffering standards are met. And here the planning board did not determine that the buffering standards were met because they didn't determine that there was light versus heavy commercial. We would submit, because it was heavy commercial, it required a buffer on the front property line here. And they'd never proposed a buffer to buffer this, this intense use of a restaurant, a campground restaurant, from the public and from 102. Almost done.
All right, I'll give you 2 more minutes.
Yes, and actually I'm not gonna even go over these slides. There are 2 more issues. One has to do with sufficient water supply. The only point I would like to make here is that the error here was that the applicant used calculations to determine whether there was adequate water using recharge, but they used the entire 43-acre site rather than the roughly 20 acres that will actually be occupied by the campground. And that was an error. And then finally, on the safe and helpful conditions, the board never, AWL never presented evidence that the site would maintain safe and helpful conditions for pedestrians and bicyclists on Route 102. So finally, in conclusion, members of the board, we believe for these 7-8 reasons, and I would like to address Mr. Cohen's question of the residential dwelling unit. He is correct that we did not focus on the residential dwelling unit issue before this Board of Appeals. And we did raise this issue before the planning board. And although we decided not to focus on that, I don't believe it has been waived. And furthermore, your ordinance does allow the Board of Appeals to interpret the ordinance. That's your job. And in interpreting the ordinance, if you decide that these were residential dwelling units, that's your prerogative, whether or not we have focused on that. In conclusion, what I would like to say is that if you go back to the Board of Appeals standard of review, for all of these 8 reasons, or for any one of them, all you need is to find one of the reasons that we've articulated or a reason on your own when you interpret the ordinance. We believe that the board should reverse the decision of the planning board because the decision of the planning board was clearly contrary to specific provisions of the ordinances, both the land use ordinance and the site plan review ordinance. Thank you very much for your indulgence. I'll be happy to answer any questions at whatever time the chair would like.
Okay, if we can get our screen back, Jesse.
Within the 2-hour limit, Madam Chair, will AWL as applicant and property owner be able to respond?
Yes, that's why I wanted to check in at 7 o'clock and see where we were. What what I'd like to do, and I just want to check in with my fellow board members, can take a few minutes and ask some questions that might be burning for any of you to Ms. Chow, or I'll move to Mr. Hamilton and let him present on behalf of AWL the response to this appeal. Does anybody have something they really need to ask Ms. Chow at this point? Or can we move into Mr. Hamilton's? Okay,
Well,
I think,
You're
Go
not
ahead,
asking
Rick.
us if we ever have any questions for her. Or I mean, you're gonna have a question period later.
yes,
Okay.
I would like to, after we hear both sides, I would then like to open it up to questions of Ms. Chow and then questions of Mr. Hamilton. They can ask of each
Okay.
other as well. Yes, so, yes, well, it's fresh in our minds. Mr. Hamilton, you have the floor.
Thank you, Madam Chair. I'm going to recognize Kenya Hopkins for 2 minutes in just a moment. I'm going to share my screen. Mr. Dunbar, is there a possibility that you could share host? Thank you, Jesse.
I just have to call Sue from downstairs and I'll tell her.
Can everyone see that?
Yes, we see
Yeah.
a woods type picture. It says Acadia Wilderness Lodge.
Thank you, Madam Chair, for that clarification. So Chair Harris, members of the board, my name is Andrew Hamilton. Longtime land use attorney at Peabody in our Bangor office. I have to first say I respect each of you for your service, your patience, and your persistence in reviewing the very large record of the 7 meetings over 6 months, totaling 1,603 pages. I'd like to advance to this plan and just focus on this purple-pink boundary site plan that we presented both to the planning board and to the main DEP. I take umbrage a bit at CTR's council's claims and will use facts and law to respond to those, but I don't think much of what was said accords with the record, the facts, and the law. And so I'd like to say that the planning board did a remarkable job, one of the most thorough scrubs the town of Tremont has ever seen. There were 2 sets of findings under 43 applicable review standards. Together, those planning board findings totaled 19 pages with 15 conditions of approval. And you have the extensive pre-hearing submittals of both parties. So that's a lot of work you've already done, and there's more to come. The Board of Appeals review is narrow in this proceeding. I don't agree with CTR's counsel. I think there's really only 2 questions. Are the planning board's findings supported by substantial evidence? And I've got a full box of notebooks of the record in my office here. I'm sure some of you that wanted a paper copy of the record, which we provided. We wanted to make sure the Board of Appeals had the full record, either electronically or in paper. You've already done an extensive review, and I respect the board for doing that. But the first question is there substantial evidence? And we'll talk about that more in a moment. The second question is, are those findings clearly contrary to the ordinance's review standard called into question? In this case, the record and the board's findings demonstrate that the AWL appeal fails the test, and therefore the appeal must be denied. They have tried to raise 10 issues to poke holes, but the record and the planning board findings are sound. The wall has not been breached, and the planning board's integrity and the applicant's integrity is sound and has not been breached. With that, I'd like to turn to Kenya Hopkins for brief observations.
Thank you, Andy. Good evening, Chair Harris and members of the Board of Appeals. My name is Kenya Hopkins, and I am pleased and grateful to have this opportunity to address you. With my husband, James, we have pursued our campground application over several years. We only did so after we were fortunate enough to have the opportunity to buy the land from a couple in Wisconsin once they decided to sell the land in September of 2019. Again, we did so after we checked with our local planner, the town, and the town's ordinances. The land use ordinance states specifically that a campground is an allowed use for the land that we now own in the RB zone. In fact, the RB zone is the only zone which allows campgrounds. And so you have to understand our surprise when at a public hearing, I heard neighbors tell us that we could not use our land for a campground because this particular group would be uncomfortable and inconvenienced by my property and my project that will result in my presence in the town of Tremont. We therefore had several neighborhood meetings and conversations to try to understand the concerns and help them to be more comfortable, not only with the project, but with me as well. I attended every planning board meeting. I spoke from my heart and I followed the rules. With a modified plan of the Acadia Wilderness Lodge campground, after listening to all of the concerns of the neighbors, I even reduced the project by 2/3 and took away all RVs. That's when Drummond Woodsum got involved, which I found strange since I was accommodating neighbors and making very serious compromises. Unfortunately, it became clear that CTR formed as a way to prevent compromises from being accepted by the community. Nevertheless, our team worked through 7 public hearings and meetings before the planning board over 28 hours and 6 months, with each meeting averaging over 4 hours. I've been told from those who have knowledge of the town's history that the planning board review that I received was the most extensive review they have ever witnessed in the history of the town. The planning board did their work after they put us to the test, and they rendered their final decision with 2 sets of findings totaling 19 pages and 15 conditions. All that being said, we hope that you can reach a prompt decision because we would like to be able to proceed with our project. The delay costs us more and more every day. Thank you for listening to my very serious and sincere concerns. I appreciate each and every one of you, and I appreciate your time. And now I'd like to turn it back over to Mr. Andy Hamilton. Thank you.
Thank you, Kenya. I think we're in 6 minutes in, Chair, into 15 minutes that was allowed for CTR's council. So I'll move with pace. I want to provide foundation. It's clear that what's happening is CTR has decided tactically to raise issues in an effort to try to undermine the integrity of the planning board's review. And I find it challenging given all of the work that was done, all of the review that was done. There was not a rush. 28 hours, 7 meetings, 1,600 pages of a record. I'll address each of the claims, but I think those claims should be put in context, particularly in the context of the legal foundation. First, with respect to these legal authorities, and I just want to address Member Cohen's question, Member Hayes' email question summarily. This issue of whether we have residential dwelling facilities or not here is a function of the prior 2019 project, and this Board of Appeals decided in response to a series of questions raised by Cynthia Lawson as appellant that these were not residential dwelling units. The definition of residential dwelling units requires, it says it's a room or group of rooms designed and equipped exclusively for use as a permanent, seasonal, or temporary living quarters for only one family at a time and containing, and this is the triad that's been discussed in many law court opinions here in Maine, cooking, sleeping, and toilet facilities. Neither the Acadia Wilderness Village, we kind of object to CTR creating new terms for our projects. You have Acadia Wilderness Village, which was an 11-unit project. That was appealed in 2019, and this Board of Appeals determined that there were no cooking facilities, and therefore these were not residential dwelling units. They were campground units. And I kind of object to the idea that we can replow old ground and look for the opportunity, because there's a different appellant this time, to raise the issue. Ms. Lawson, who's a core member of CTR, went through that appeal. This board knows that that determination was made. I would just refer the board back to its decision in 2019. What I think is key here is to understand that the appeal is limited to issues raised in the notice of appeal. Other issues are waived. That was made clear in Wells v. Portland Yacht Club. Issues are constrained to the four corners of the pages of the notice. As zoning ordinances are in derogation of private property rights, and you've heard Ms. Hopkins speak to the property rights of Kenya and James, her husband, they're given strict interpretation and may not be extended by implication. Much of what CTR's argument was before the planning board was to reach to conclusions that are not currently in the law. It is aspirational or by implication. Moyer versus Board of Zoning Appeals, the law court said early on, you can't extend zoning by implication. Although interpretation of an ordinance is a question of law, the Board of Appeals accords substantial deference to the planning board's characterizations and fact findings as to what meets ordinance standards. An appellate review by a Board of Appeals is not a do-over opportunity. It is not a de novo review. You had a de novo review in December. You were invited by the appellant at that time to send this along to the courts so that they could occupy court time with a prior appeal. That appeal is not pending before this Board of Appeals. So issues associated with Acadia Wilderness Village are not before you. You already moved that appeal to the courts. It's before the Superior Court. Moreover, that was a separate project that was reviewed in 2019 and approved in 2019. Further, on appellate review, the Board of Appeals can't make findings independent of those explicitly or implicitly found by the planning board or substitute its judgment for that of the planning board. So we come to the standard of review. Can the planning board's decision be reversed? Yes, but only if you find it's clearly contrary to the provisions of the ordinance. I'll speak to that more in just a moment. You also would need to find that the decision is not supported by substantial evidence on the record. I submit, as we've said, 1,603 pages of transcripts means that for every one of the claims by CTR, you can find substantial evidence. CTR's counsel endeavors to assert that because she had one expert in the whole proceeding, who was not an engineer, by the way. Matt Reynolds is a groundwater hydrogeologist. I know Matt Reynolds. I've worked with him in many projects, but the law is clear. Simply creating a conflict in the evidence doesn't change that it's competent and substantial evidence. It just means there's conflict. You have to weigh the evidence. So I'd like to talk a little bit about what the term clearly contrary means. It's not defined in your ordinance, but your ordinance directs you to the plain dictionary definition of the term in Webster's Collegiate Dictionary. Webster says that contrary means being so different as to be at opposite extremes, a fact or condition incompatible with another, the opposite. If you watch the planning board, and those of you who know Mark Good, those of you who know Lawson Wilson, those of you who know Brett Witham, know that they're very careful people. They took their time with counsel to address every one of the claims that CTR and its counsel made before the planning board, many of which have been raised again tonight. And we're looking for a different decision from a different board on many of those issues. And I'll be specific on those because I took careful notes of some of the new claims that are coming even tonight. But I object to the notion that because the Board of Appeals is doing an appellate review, you get to substitute your judgment for theirs, because there's no sense in which there's a compellingly contrary finding by the planning board. Please return to the 19 pages, the two sets of findings by the planning board on 43 review standards. Every one of the review standards was covered, including all the claims that are being raised again this evening. So now we get to this question of conditions. And you will note that in Article 8, Section E1, after the submission of a completed application to the planning board, it shall approve an application or approve it with conditions if it makes a positive finding that the project meets the specific land use ordinance review standards. CTR's counsel has it backwards. The planning board first determined whether findings could be made, and then after findings of compliance with the ordinance standards were made, then and only then did they move to the conditions. And many of these conditions were voluntary offers. What I find difficult about the representation that's been made is that somehow we were trying to do things that would evade the site law. I know the site location and development law. I've been practicing development law for 38 years. There was every disclosure that had to be made to both the planning board and to the DEP was made. And I really regret the fact that CTR's counsel has suggested that the planning board was complicit, these are my notes, was complicit with the applicant in evading the site location and development law. You see from our briefs that we provide the exact reference to when we provided a September 29 letter to the Maine DEP saying, here's the project. We want to know if you want us to get started into the site law or whether we should proceed without the need for site law review. That question is pending, and this Board of Appeals shouldn't be taken down that primrose path of suggesting that a planning board of yours that has great integrity is somehow participating in evading the site location development law. Moving on, I think Fightin-ides and City of Portland versus Grace Baptist Church stand for the proposition that whereas here, both your site plan review ordinance and your land use ordinance say, once the board makes findings coherent with the evidence and the standards of review, then you move on to conditions. So here's what the law court said. To further the purposes of the ordinance, the board has the authority under the ordinance to approve a site plan with conditions. Fightin-ides is a really interesting case, and it really merits the Board of Appeals review with its counsel. There, the court stated the condition delegating decision-making to the city planner. Here, Tremont does not have a city planner. It has a municipal code enforcement officer. And that's what happened is in a couple of these conditions, there was delegation to the code officer to gather information to determine that the approved standard would be implemented correctly. This is about voluntary offers and making sure those commitments are kept, and about conditions that require that things that the ordinance standards be found following development, that the evidence is presented to a municipal official. I find it instructive what Fightin-ides says. The condition delegating decision-making to the city planner furthers the purposes of the ordinance by ensuring that even minor deviations from approved plans will be subject to municipal review for compliance with zoning and building laws without unduly burdening the planning board. Put yourselves, if you would, members of the Board of Appeals, into the shoes of the planning board. They spent more than 28 hours on the review of this project. Do you think they want every question back that could conceivably be given to the code officer or the planning board just because CTR generates a collaborative or conspiracy theory? Again, I find that objectionable. So here's why it is not appropriate in the first argument made by CTR to agree that these are a single project. We never use the terminology AWL1 and AWL2, and please strike it from the record. The name of the first project is Acadia Wilderness Village, an 11-unit project. The name of the second project is the Acadia Wilderness Lodge project, and it went through a revised stage because we modified to reduce by 300% the density and removed all the recreational vehicle sites. But here's the facts on this timeline of the two projects. The project was wholly approved in 2019, and the Board of Appeals denied the appeal by a 4-1 vote on July 18, 2019. Then some 4 to 5 months later, there's an opportunity because Lawson's from Wisconsin, not from Tremont, decided to sell their property. The property was offered for folks to bid in and have the opportunity. The Hopkins bid in, as did some other local residents. The Hopkins got the opportunity. The Lawsons decided to sell to them, and the property was closed on November 8, 2019. It wasn't until months following that the Acadia Wilderness Lodge project was proposed. And that project went through 2 stages, as has been discussed tonight. But the notion that there was some designation of 2A and 2B just makes really silly and small the fact that the Hopkins worked hard through 3 neighborhood meetings to work with neighbors, come back with a project that had only 55 units total as compared to 154 originally. 72 RV sites were proposed originally. No RV sites were proposed in the revised. The second claim is that there's somehow some inadequate single emergency access. First of all, emergency access is not required, but it's provided here. The division planner for DOT, Diane Morabito, a traffic engineer with Sewell, who's here tonight and can answer any questions that you have. And Haley Ward, the peer review consultant for the town, all said that the study established that neither accident rates, what we call high accident locations, there are, by the way, no high accident locations within the 3-mile stretch of road that includes the site driveway. There is no record of any accidents in the last 3 years within the 0.57 miles that brackets the site driveway. And it was questioned by CTR whether DOT even knew the project. And what Craig Kosabud, who's the regional planner for DOT, said, on or about September 28, 2020, we, the state, issued a permit to James and Kenya Hopkins for a campground on the Tremont Road, Bernard Township, Tremont. I have been to the location 3 times to look at site distances, drainage, width of entrance, and other logistics. And he signs off to the right. You can see he issues the driveway entrance permit. So issues 2 and 3 brought by CTR are not supported by substantial evidence, nor is the finding by the planning board clearly contrary to the traffic standard in the ordinance. The next one is the developed area boundary being designated. And I have to say that this really irks me that this project and the Hopkins in particular decided to be empathetic to their neighbors on the back portion of this land, including Mr. Buck, and said, okay, we've heard the concerns with having as many as 154 units. We'll scale down to the 55 unit project that you can see on the left. This is the buffering plan that was submitted to the planning board September 14, 2021. And then the plan was submitted to DEP with a letter from Greg Johnston on September 29, 2021. And we put this plan into the record. The reason Ms. Chow has been using this plan, as well as Acadia Wilderness Village, is because we provided this plan. CTR's counsel has been taking excerpts from this plan and using it out of context in ways that we have found objectionable before the planning board, and we find objectionable before this board. The bottom line is we proposed the boundary that you can clearly see as the developed area boundary and said area outside that will be retained. That's a total of 24.41 acres. Conditions 2 and 9 act to implement a determination by the planning board that we had shown the property boundaries. The perimeter property boundaries are shown. There is no requirement to divide the lot, but I can assure you that CTR's counsel wants a subdivision here that has to be reviewed. And so they want the first parcel to be Division 1. They want the second to be Division 2, and then a boundary that is not required under the ordinance to be Division 3. So what did we do? We gave the assurance that once this project cleared permitting and once this project cleared the appeal, we would have a survey of the boundary setting off the developed area. We would flag it so campground unit occupants would not be walking into the buffer area. It is true that we took property that's pretty valuable in Tremont and said we would retain it as buffer for 5 years. But what the CTR's council didn't say is that we said on this northerly parcel, we would never develop a campground. And that assurance has been given to the neighbors and we will abide by it. The next one is light or heavy commercial use. And I have to say, there have been some fairly novice views expressed about whether light or heavy commercial use is a use designation. Nothing could be further from the facts in the ordinance. All you have to do is look at the ordinance on its face, and you can see that light commercial, as CTR's council admitted tonight, is in the purpose section of the zoning district. It's the PB district. And light commercial is referenced as something that's within the purpose. But the only place where campgrounds are authorized in Tremont is the PB district. That's the only zone where campgrounds is a designated use. The notion that the attorney for the planning board would even need to advise the planning board that light commercial is neither a use designation nor an ascertainable standard, I found surprising, but that's what she said, and she was right. There's nothing about light commercial that's defined in your ordinance. It's just used as part of the purpose section. Moving on. Now we come to a question that I have worked with for decades. I worked with it in Bar Harbor. I've worked with it in Southern Maine. I've worked with it in Northern Maine, where I'm from. I worked with it in Central Maine. And that is, what's the correct version of the land use ordinance to apply to pending proceedings? Attorney Chow is trying to get you to say that your ordinance says something different than Title I, Section 302. I took careful notes of what was up on her slide. And what she cites to is a provision of your ordinance that says that once a project clears completeness review, it's pending. Well, folks, that's what happened. With the original project, we were pending as of March 23, 2021. And then what the standards really say in the law that weren't cited by CTR's counsel is it's when you start substantive review, irrespective of when there was a completeness review. That started on April 27, 2021. We held forth and the planning board took argument for a couple of meetings on the question, is this a new project or is this a modified project? Before it was a campground with 154 units. After it's a campground with only 55 units. Because the developer made an accommodation to the neighbors and to the town to reduce the density of the project, does that mean it's a brand new project as though it's no longer a campground? No, it's a modified project and it's modifying the pending proceeding. And so what we have here is the observation by Attorney O'Connell, quite correct, an additional completeness hearing is not dispositive on whether there's a pending proceeding. There's a law court decision that says exactly what Attorney O'Connell said. So we were properly handled under the 2020 LUO, but I have to say the setback issue we need to talk about. And so here it is. The leach fields, and you can ask Greg Johnson, and I would ask you to please ask the project engineer and not an attorney that may not be totally familiar with how to read a plan as to where a leach field is and where it isn't. The leach fields are outside the 50-foot setback. Not that they needed to be, because we're subject to a 25-foot setback. The distance between the front porch of the farmhouse and the property line along Route 102 is 30 feet. That meets the 25-foot setback. And the distance between the farmhouse and the property line to the east is 80 feet. Both are adequate distances to meet the applicable standard for buffering. The setback line illustrated on the submitted plans is 100 feet. 4 times the required distance of 25 feet. So generally, we use a 100-foot setback for this campground. It's very generous. It's way more generous than the ordinance standard. But when you get a picayune approach to specific locations on the project and plans that are misread, like leach fields, this is what happens. We met the setback requirements. The next one is whether the law authorizes a planning board to set conditions. I'll return to this in a moment. But because Attorney O'Connell used the Jakes case, I think correctly, I wanted to point out that, as I've said tonight, that's not the only case law court decision on conditions. The law does authorize a planning board to set conditions. There you have it in 3 law court decisions: City of Portland versus Grace Baptist Church, Phytonides versus City of Saco, Total Quality Inc. versus Town of Scarborough. As counsel for CTR knows, they're long steeped in zoning law. The question is whether the ordinance allows for conditions. Your ordinances allow in 2 places, as I briefed the board tonight, allows for conditions to be imposed. What you can't do is use a condition to substitute for the compliance with the review standard. But again, CTR's counsel has it backwards. Conditions were not set before the findings were made by the planning board. You would have had to have been in the meetings, the 8 hours of meetings, as I was, to watch 3 planning board members wrestle in earnest with the evidence, with the review standards, and then make their findings upon consultation with counsel for the planning board. No one who was not in that proceeding, unless they've read the entirety of the transcripts related to those 2 meetings, would understand this. And I think you need to understand that the appellate review standard doesn't put you in the position of doing a de novo review. Your opinions about what you think is appropriate for this project, that's not the question. The question is there competent evidence to support the findings? So let's get to this maintaining safe and healthful conditions. And I have to say, there's ample law court precedent that this particular standard is way too subjective. It allows the planning board to substitute its judgment for the legislative body, and it's called an impermissible delegation of legislative authority. And the courts have struck decisions that use this as a basis to deny projects. In fact, the planning board was invited by members of the public to say 102 is already a busy road. And oh, by the way, Acadia National Park brings a lot of people to the island. What does that have to do with a review of a specific project under the review standards? It doesn't. We are not responsible for the conditions on Route 102. The question is whether we will maintain healthful and safe conditions. We had lots of evidence here. We had the Craig Kosabud review. 3 times he goes out from the DOT regional office. That's record for the DOT. We had Diane Morabito, who did an analysis of the level of service, the high accident locations, the accident history along this roadway. It's not nearly as bad as was represented by lay witnesses. The planning board was entitled to rely on the substantial evidence presented by Diane Morabito, a long-standing traffic engineer from Sewell Company. The planning board had substantial evidence when they relied on the determinations of Carl Kosabud. But finally, the town's independent peer reviewers, Haley Ward, that has traffic engineers, reviewed the traffic study, reviewed the project engineers' prior information, and concluded that AWL met all traffic safety ordinance standards. Here we come to the adequate water supply. And I have to say, that's what was most frustrating about tonight, was the misrepresentations about what I said in the record and what Arnie Fessenden, a competent geologist whose reports were presented to the planning board. Greg Johnston presented information. Dave Moyse presented information. You can see the team on the top of the slide. They combined to present evidence as to groundwater quality at the property line. The challenge is the review standard, if you study the review standard closely, also requires that the planning board have a process in place so that groundwater quality is protected following the development. So there's a future condition that has to be addressed through a condition of approval. Now, these three gentlemen, Greg, Arnie, and David, did remarkable work. They presented reams of information to the planning board. CTR's counsel did her work. She presented a witness who was going to disagree with those three individuals. But the weight of the evidence in this case supported the planning board's determination. On top of that, there was a first of its kind drawdown test on adjacent property that is in the same watershed as Acadia Wilderness Lodge. That's the first time that's ever been done in Tremont, I've been told. Why was that done? To see what happens if you draw down water in the water table at one location, what impacts will it have on abutting properties? And then the notion that we didn't test groundwater quality is similarly an overextension of Matt Reynolds' testimony. He said that what other communities do might need to be done in Tremont, but then acknowledge the Tremont ordinance does not have a nitrate analysis requirement. We nonetheless did a mass balance analysis, and I disagree with CTR's counsel that that was a last minute presentation. We had information in the record from Arnie Fessenden that demonstrated that a mass balance analysis had been done. And it showed that we would not have higher than 10 milligrams per liter at the property boundary. And I've gone through a lot of nitrate analysis work in my practice, and I would say I'll go toe to toe with what was said that night. And the thought that I misrepresented the record, I severely object to. Finally, the entire October 26, 2021 public hearing produced 237 pages of transcript. Mark Good, as the chair said, this meeting tonight will be dedicated to water supply. So all parties were on notice, as Attorney Chow indicated. We all submitted our evidence. We all had a chance to test our evidence. And then the planning board much later made their final findings. Again, two separate projects. AWV, Acadia Wilderness Village, is not before you. The planning board and the Board of Appeals have both found in Tremont that we don't have residential dwelling units because we don't have cooking facilities, either at Acadia Wilderness Village or at the separate project, Acadia Wilderness Lodge. I have to say, the fact that the planning board was induced by CTR to adopt a standard that would make clear that you could take two adjacent projects like this and treat them together, to me, goes hand in glove with the fact that CTR itself brought a quick appeal to you in December, didn't even want you to hear the merits, and said, we're going to court to see if we can get a good cause extension because we want to relate back to the previously approved 2019 project. The project that is before you is not the project at the bottom, the 1.6 acres. That project has been permitted, approved, and hopefully will soon be opened. And I disagree that the planning board did not see this map. They saw this specific map because we submitted it to DEP on September 29th. Thus, there was no intention to try to evade the site law. We disclosed to the main DEP, excuse me, CTR council. And the planning board saw this because I submitted this under a cover memo to the planning board dated October 5th. But the Acadia Wilderness Lodge project is the project that you see outlined in green. Mr. Johnston, highly ethical engineer, showed this project to the DEP because DEP does have a test, unlike the town of Tremont's local ordinance. And unlike most other local ordinances, DEP has a unique test called the Common Scheme of Development test. We know we have to be below the thresholds for excavated and unrevegetated area and for developed area under both thresholds of the site law. Happy to answer any questions. I think we're well under time.
Yes, you are. Thank you. I think the way I'd like to proceed is see if any board members have questions first of Attorney Chow? Okay. Mr. Hamilton, do you have any questions of Attorney Chow?
I don't think it's productive to get into back and forth between counsel for each side. So for now, I'll defer. If there's something that I can offer directly to the board to be helpful to the board, I'll do that. But I don't feel the need to cross-examine my good colleague, Amy Chow.
Okay. Well, you under our ordinance, you are given that opportunity. So I just want to make sure you had it.
I understand.
Any
Madam Chair.
questions? Okay. Any questions of Attorney Hamilton from members of the board?
Yeah, I have one.
Go ahead, Rick.
Mr. Hamilton, I have in front of me the resolution with the conditions that the planning board put on its approval. Number 6 is the one that I'm focusing on. Do you have it in front of you?
I do.
Okay. My question to you is what role the planning board has in that process, if any? I mean, I understand that the CEO is going to review stuff. And if he's satisfied, he'll file what he's reviewed with a recommendation with the planning board. What's the planning board supposed to do with that?
So if I can provide context for my response, if you look, Member Cohen, at both findings J, water supply, Brett Witham made the motion that the condition for water supply had been met, Article 9J, because the record states, including through the Haley Ward peer review of October 1821, that the development is provided with an adequate water supply. In addition, finding N, again, under the site plan review ordinance, Member Cohen, contains a finding: the proposed site development and use must not adversely impact either the quality or quantity of groundwater available to abutting properties or to public water supply systems. Mr. Wilson made the motion that the condition for groundwater protection has been met on the condition that the applicant must meet all state standards as part of review of the final design of any and all engineered wastewater systems, and must demonstrate to the code enforcement officer, who will make a recommendation to the planning board, that the groundwater at the property line will comply following development with the standards for safe drinking water as established by the state of Maine, including by conducting a state-approved form of nitrogen nitrate analysis at the property line. Mr. Witham seconded the motion, and the chairman then conducted a roll call vote, which was approved by a 3-0 vote. So you can see, Member Cohen, that condition 6 is embedded into finding N. So the planning board did two things. One is they first made their finding, and then they repeated the condition that Member Wilson advanced, because you've got two things going on in that standard. You've got engineered wastewater systems. That's number one. Engineered wastewater systems can generate nitrogen and nitrates, okay? But until you submit a plan for an engineered system, you can't get state approval. Everybody knows that. And so the planning board said, we want that to be checked. They then said in condition 6, as they did in finding N under the site plan review ordinance, that this material had to come to the code enforcement officer. Exact same process that the law court talks about in Fight 90s versus City of Scarborough, excuse me, City of Saco. What the law court was talking about is it is appropriate in certain instances to delegate the implementation of a condition to a municipal official and make sure that everything is checked, that it works. The role of the planning board is that it needs to get a filing from the code officer, who first needs to be satisfied that the information provided is satisfactory. That condition leaves, to me, open the question: if the filing is not made, or if the filing is not made adequately, the planning board and an interested party can look at that condition M and say, we think the necessary filing with the code officer was not done. We want to bring this back before the planning board. So the finding in condition M is made by the planning board. It goes to the code officer. A filing has to be made to the planning board, and then folks can put the ball in play. I would note, Member Cohen, just as CTR has put the ball in play as to the old Acadia Wilderness Village project that was approved in 2019, what have we got for an appeal? We've got an appeal pending before the business court right now, and it came through your board. So appeals can be filed, petitions can be made to the planning board. If your question is, does the planning board have no role? I don't agree. I think the planning board does have a role. It used the role.
It was a question. I didn't make a statement. Do I take it your answer is that if the appropriate material is filed with the code enforcement officer and he's satisfied with it and files it with the planning board has no obligatory role after that?
So, Member Cohen, I know that you've both practiced law and reviewed lawyers' work as a judge. And I would say to you that you're aware that when parties are highly participatory in a proceeding, they don't just go away. I don't suspect that either attorneys Chow or Spencer or their successors, if they're ever replaced as counsel, will fail to come to the planning board and say, we either didn't see a filing or we saw a filing that was inadequate. If that happens, they'll be back before the planning board. This planning board is diligent. I believe you will see a reopened proceeding before the planning board. So do we have to dot our I's and cross our T's? Yes. Does the code officer have to file with the planning board? Yes. If you're the thrust of your question or the premise of your question is it done with the planning board? That's not how I read that condition.
Are you all set, Rick, or do you have a follow-up?
No, I think I'll subside on that question.
While you're putting your thoughts together, Mike has a question.
That's
Go ahead,
all. Joanne, I thought I have only one more.
Okay, sure.
And it's also from Mr. Hamilton. The 2019 resolution approving the Wilderness Village. At the time, there were no yurts with refrigerators and counters and sinks and stuff like that, right?
I know that there were sleeping facilities. There were claims that there were toilet and cooking facilities. And I'm looking at page 3 of our appeal brief to this Board of Appeals on that very development.
Yeah.
And we said the following: the land use ordinance at section 11 defines residential dwelling unit as a room or group of rooms designed and equipped exclusively for use as permanent, seasonal, or temporary living quarters for only one family at a time and containing cooking, sleeping, and toilet facilities. A conclusion nearly identically raised and addressed by the law court in 21 Seabrand LLC versus Town of Naples. The bottom line is the term cooking, although not defined in the ordinance, we go to the dictionary and it says suitable for or used in cooking. There were no cooking facilities in Acadia Wilderness Village. And thank you for using the appropriate name for that development, Member Cohen. There are no cooking facilities within Acadia Wilderness Lodge. And so we have a failure of the 3 requisite requirements.
Is it your suspicion, just between the two of us, nobody else is listening, that the board's 2019 resolution is the reason that Ms. Chow did not ask us to review that objection that they had before the planning board?
No, I think I correctly heard Attorney Chow say that she did raise questions, and I do remember that she did raise questions related to that issue. I recall that the board said we don't have cooking facilities, and so under our ordinance, we don't have residential dwelling
Oh, yeah,
facilities.
no, I understand that. No, my question to you was whether or not her decision not to raise that issue before us is because we had dealt with it in 2019.
I think that's certainly possible, Member Cohen, but I would say of my good colleague, Amy Chow, she really avoids waiver like the plague. She will raise all questions that she can raise. And that's why I think she raised it before the planning board. So whether it was the Board of Appeals or the planning board, I just don't think that's a good legal issue. And I think she's decided she's not going to pursue it further. But that's a question for her.
We'll see. Okay, thank you.
Yes, sir.
Mike.
Thank you.
Just out of curiosity, I went through the planning board ordinance, the land use ordinance, and the site plan ordinance, and I saw nothing in there that said that that board can delegate decision-making responsibilities to the code enforcement officer. I understand about conditions. Okay, but generally, if you say, okay, if you do this, then we will do that. So how is it that we infer, or you infer, that it was approved, even though the responsibility of the board had not been met, and there's no provision in those ordinances for them to delegate that decision-making responsibility?
But you see, I don't agree, Member Hayes, that the standard was not met and that the planning board in any way failed to do its job. Here's why. There were a series of nested issues that had to be teased apart under the review standards. And I've given in my colloquy with Member Cohen the different sections that have to be met. I don't agree that the planning board doesn't have authority to delegate follow-up implementation. That's what the law court has said. And I cited the Fidenides case. And because the planning board was advised by competent legal counsel, she brought legal authorities forward for their review. And I think she concluded, I not only concluded the night that she advised the board, I've concluded, having looked at this 3 separate times since then, that the main law is clear that the planning board can delegate authority when what they're doing is following up to make sure that there's proper implementation. The challenge is that this campground will rely on an engineered system. And we should ask Mr. Johnston, if you're really curious, Mr. Hayes, why an engineered system does require follow-up by a local code officer once design review has been done at the Department of Human Services. That's what has to happen here. And no project that I'm aware of that relies on an engineered system has the ability to do the final review. Then the second piece that I object to is the notion that we had to provide a nitrate analysis. There was nothing in the ordinance that required that. In fact, Mr. Reynolds was quite clear saying that Falmouth and I think even Brewer had a requirement that you had to do it. But the requirements of an ordinance are in derogation of common law property rights. And if the law doesn't require it, it doesn't require it. Nonetheless, Greg did with Dave Moyes and Arnie's support, a mass balance analysis to look at what would nitrates be at the property line once properly treated. And they readily came to the conclusion that the standard of the Safe Drinking Water Act requirements would be met. I mean, the last thing that these applicants want to do is to foul anybody's well water. I mean, why would you ever want to do that? And so the planning board pushed us for an entire evening. It was a 3-hour, I think it was longer than 3 hours, at an entire meeting to gather all the evidence. The evidence was tested. Claims were made on both sides.
I wasn't arguing that point. I was asking the question about where in the ordinance says they can do it. Let's let that aside. I have a couple questions that I would like to ask, and I think one probably goes to the town attorney and the other to Attorney Hamilton. This is to our town attorney. My memory was that you indicated that if a term was not defined, then the Merriam-Webster dictionary was considered the source of that definition. Is that still correct?
Yeah,
Okay. And this then goes to the filing from Attorney Hamilton. It is on your page 2 of the response document. It's the first line in the, well, it's actually several lines in the second full paragraph. And it said, on August 10th, 2021, AWL informed the town and members of the planning board that AWL would modify the layout of the pending application and that the modifications reflect AWL's desire to address comments from the board during prior application. Correct? I don't want to.
Yeah, you're reading from the brief, and I agree that that's what we said in the brief.
Okay. Have you looked at the Merriam-Webster definition of modify?
Yes, I've looked at numerous dictionary definitions of modify, and I would say that before we conclude that Merriam-Webster is the only dictionary we can use, I just want to check something. I need the land use ordinance. I've got it right here. One second. Because what the law court has said, Member Hayes, in a number of cases, is that we use a customary dictionary meaning. There are some ordinances that use Webster's New Collegiate Dictionary. There's some that use Merriam-Webster.
I was told by our attorney that it was Merriam-Webster, which was specified for the town of Tremont. Is that not correct?
No. I was just testing my own recollection. It does say latest version of Merriam-Webster's Collegiate Dictionary.
Okay.
Yep. Go ahead, Member Hayes.
Well, I was just going to say the definition in the Merriam-Webster dictionary is that to modify means to make minor changes. And
Right.
you have come forward and said that the changes made from the original plan were not minor, they were major. You've made a point of that time and time again to us. These were major changes to that plan. And my understanding is it necessitated changes in the road system, water supply, septic handling, a number of what you have said are major changes to that plan. And I'm just trying to square this circle about what a minor change is and what a major change is.
Well, again, I'm somewhat steeped in the law in this area of what is a pending proceeding and what's not something that takes you out of the box of being a pending proceeding. When we applied originally, early in 2021, we were a 154 unit project with 72 RV units. The impacts associated with that project, I can tell you, have been substantially reduced by a 55 unit project with no RV units. It is pretty standard in Maine zoning law, in fact, I think across the country, that when you reduce an application, when you reduce the scope of an application, that's not viewed as creating major impacts. That's viewed as, if anything, creating minor or less impact. So I'm familiar with your line of inquiry because I'm facing it right now in a statewide case involving the word alteration, which also has a similar definition to modify. And alteration means you don't change the nature of it. And what I'd say to you is what we hung our hat on, what I've seen Maine courts hang their hat on, is whether you've changed the nature of the use. We didn't change the nature of use. It was a campground before, it's a campground now. We did very substantially reduce the impacts. And that's why we argued that this was not only not a change in the nature of the use, but it was minor as to its impacts. And that's what land use review does. It tests the option.
I understand your argument.
Yeah,
I really do. I was just hoping for some assistance and clarification. So thank you very much.
Madam Chair, a point of order. Since a number of these questions have addressed, I understand they've been addressed to Mr. Hamilton, but a number of them raise legal issues that I haven't had a chance to be heard on. And I would briefly, when you find the time appropriate, like to do a brief rebuttal on the legal points that Mr. Hamilton has raised just in the last few minutes, please.
Sure. I have a question I'd like to pose to Mr. Hamilton. I'm looking really for clarification here. Am I to understand that the road system within Acadia Wilderness Lodge, there is a connection that you literally, as I understood it, you can't get into Acadia Wilderness Village without going through Acadia Wilderness Lodge? Is that true?
Yeah, because Mr. Johnston really has the specifics on this. I'll defer to him in a moment, but you're essentially correct, Chair Harris. The notion is that there was a lot of concern expressed by Kelly Road residents, Kellytown Road residents, that folks would start using the Acadia Wilderness Village 11 unit entrance to get over to Acadia Wilderness Lodge. We should place bollards and use a chain or gate to block off access from Kellytown Road. That is the condition in being, and we won't get a building permit for Acadia Wilderness Lodge until a condition that has to be met as to Acadia Wilderness Village is squared away. But I believe your assumption is correct, Chair Harris. Anything different, Mr. Johnston?
I think if I could just add that the condition in the ordinance encourages to place vehicular movements where the least amount of conflicting patterns can happen. That makes sense to consolidate the traffic to one entrance. The planning board can remember there's always been a connection. There was a shed out on that Acadia Wilderness Lodge area. There was always a Woods Road connection, and that's the road we walked during the site visit between the two. So it made sense in our experience going through the prior appeals and planning. It was just good planning. I think it's being blown up into something that it's not, other than the fact that it's good planning to consolidate the traffic. That was the reasoning behind it.
Thank you. So I have a question now for Attorney O'Connell, please. So the fact that Acadia Wilderness Village and Acadia Wilderness Lodge became enjoined, if for no other reason than entrance and egress, was there any consideration at the planning board for the fact that these two projects were actually now connected or conjoined, at least in terms of roadway? And did the planning board take any of that into account?
I mean, I think the record speaks for itself. I can't pinpoint exactly in the record where that is. There was discussion about that. It was raised by Attorney Chow, and there was some discussion about it, and it was considered. So I would have to look through the record to find exactly where that was. But I do have that recollection.
Okay.
Madam Chair,
Thank you.
I think I might ask you to notice that there was more than just a road connection. As I recall, the plans for the Wilderness Village do not include any maintenance or administrative facilities now, but they will be provided by the lodge. Which knits them even closer together. I have another question for Mr. Hamilton and Ms. Chow, if I may.
Go ahead.
Condition number 4 says that the cafe, the fitness studio, the dog park, and pool campground amenities will be open only when the campground is open and not open to the public. And then it says, unless the condition is modified by the board, these facilities will not be open to the public and will not be open when the campground is not operational. My question is, for the board to decide to modify those conditions, would it not be necessary for somebody to make an application for that relief to the planning board, and the planning board start a whole new application process with public hearings and all the rest of it? Or is it contemplated that if the board decides, well, that isn't working out too well, let's let them do something else? Or let the CEO make that decision or something like that? That's, is my question make sense?
Yeah, so for the applicant, condition number 4 deals with a matter that we thought it might be nice to be able to provide cafe facilities to the public, and not just have to do it while the campground was operating. We made a decision as an applicant that because this was a concern of the board, particularly of the board chair, that we needed to agree to the restriction. And so we felt that it would only honor the planning board's direct review because it was material to the chair and to the members of the board, that if we ever wanted to modify it, we would have to come back to the planning board. We're hoping that there'll be a groundswell of people who like coffee and they'll want to drink the coffee in the winter. And we might have support sizable enough to overtake the CTR contingent and be able to open it. I jest. I don't think there will be that opportunity, and it's somewhat sad, but it was material to the board. The applicant offered that we would not make it available to the public, and it would not be open beyond campground season. But if hope springs eternal, it only springs eternal if the planning board says yes. Nobody else can say that on that one.
Yeah, but my question was, in order for the planning board to say yes, have you agreed that an entirely new proceeding, a new application has to be made for that narrow area of relief? I mean, you can't just kind of write them a letter and say, how about it?
No, I think because the planning board meets at public meetings, the capacity of code officer is different than planning board. When planning boards meet, they have a public meeting. I can't imagine something being placed on the agenda and the public not being notified. So from a notification perspective, yeah, I think there's going to be notification to the public. Yeah.
Yeah. Okay.
I see your question.
Member Cohen, if I may, I would like to be heard on this issue as well, since your question was directed both to the applicant and to us.
Yep.
While I do agree with Mr. Hamilton that if any condition like this were modified by the board, it would have to be by way of a new proceeding and a new application and a public hearing. But I'm glad you raised it, because this was a condition that CTR fought over. And the reason why this is initially the applicant proposed to have these amenities that are supposed to be accessory to a campground open to the public. And we believe that doing so would turn them into separate principal uses if they were open to the public. So not only do you now have a campground on the property, but you have a fitness spa that's open to members of the public. You have a swimming pool where you have swimming lessons that's open to the public. You have a dog park. You have you have a restaurant that is open to the public. And suddenly that becomes not accessory to the campground use, but independently principal uses that would have required the square footage of 40,000 square feet for each principal use. That is why CTR argued that it shouldn't be open to the public. But another reason I think this condition is important to highlight is it really highlights just how integrated these two proposals are. Because not only are the roadways integrated, not only is the emergency exit supposed to be integrated, but doesn't go anywhere. But in this case, this does not make clear whether or not AWL1 patrons who are now going to be using the internal roadway on the AWL2 site can use these amenities. And what I will assure you that through advertising, they've made clear that they will be able to use them. And yet the impacts of an entirely different campground of 11 units to be able to use all of these amenities that are supposed to be accessory to a different campground that is adjacent to it, that issue simply was never addressed. It was never addressed by the planning board because AWL insisted that these were two totally separate campgrounds. And while they might be named differently, one of them impacts the other. And I'm sure that this can, under this condition, it doesn't prevent them specifically. We objected to this provision, but if I, would this, Madam Chair, would this be an appropriate time for me to respond briefly on those other issues, or what would you like me to do?
Can we get questions and answers? Because I think either one of us could turn this into an extended argument.
No, I'm just asking a point of order question about whether, would this be appropriate for me to address the other one or two
Yes,
points?
I want to make sure that no other Board of Appeals member has a question for Mr. Hamilton. And as I gave Mr. Hamilton an opportunity to ask you questions, Ms. Chow, you are given an opportunity to ask Mr. Hamilton questions as well.
I do have one or two more, pretty simple questions.
Go ahead, Mike.
It is maintained that Acadia Wilderness Village is a totally separate entity and has no real relationship with Acadia Wilderness Lodge. And yet, when the plans were submitted for what is now Acadia Wilderness Village, it was actually called Acadia Wilderness Lodge, and that's how it's referred to. And when I go and I look for Acadia Wilderness Village, I am delivered to Acadia Wilderness Lodge's website. And I'm told that's where I make reservations and that's where I check in. There's a phrase I really like. It's a distinction without a difference. And I've got to tell you flat out, this is one of those things. It's a nice fiction, but I don't think I could maintain it with a straight face as you do. So it's not separate financially, administratively, managerially, physically. How is it not part of Acadia Wilderness Lodge?
So wait just a second, Member Hayes. You got a head of steam up there. Let me just break it down for you. I said in my affirmative representation to this board that on September 29, 2021, Greg Johnston submitted to the Maine DEP that has a common scheme of development test, both Acadia Wilderness Village and Acadia Wilderness Lodge. Unlike some people who have a conspiracy theory saying, we've tried to create this separate and there's a big legal fiction, I don't agree. I think what happened is a practical matter, and I just want the history to be reflected accurately, because there's a lot of historical revisionism that goes on in our nation, and I don't like it. And I just want to be clear with the facts. Acadia Wilderness Village was approved. You're correct, sir. The name Acadia Wilderness Lodge had been used. What we're trying to do is create different experiences at two different locations on the ground. I don't think I've ever heard anyone on our team assert to either the planning board or to this Board of Appeals, we don't think those two projects have common ownership. They do. So when we took the drawing to the DEP, we put both projects on it. What I find objectionable is the Drummond-Whitson approach with CTR seems to be, you have to believe in conspiracy in order to find that the planning board did their job. And they're just such wholly separate questions that I really don't want to suggest that a very strong integrity on this planning board got into the question of was there a conspiracy? I mean, let's just
I,
face facts.
I gotta tell you, I resent the fact that you think I think it's a conspiracy. I don't think there are any bad guys in this process. I think there are
Okay,
people
so
that have objectives, and they're gonna pursue those objectives. That's what I think. Business people do business things. One last question. Where are the ocean view yurts located?
I suppose that's a question for Ms. Hopkins. Do you know, Kenya?
Hi, Mr. Hayes.
Hi.
How are you? The Ocean View Yurts, there's a ridge on the property that's raised a bit above, and Cynthia Orcutt, our landscape architect, could probably explain this a little bit better than me, but I'll try. There's a ridge on the property that's a little bit more raised. And so the yurts that are going to be placed on that ridge will have an ocean view. Because like I said, if you're on that ridge and you're looking up over, you can see the water. So it's really just that simple.
Thank you. I appreciate
You're
that.
welcome. You're welcome.
Mr. Hayes, Madam Chair, I'm sorry, I should go through Madam Chair. May I respond briefly to Mr. Hayes's point or his question? Thank you.
I don't think he had a question of you. He was questioning me.
I will ask her to do that.
Go
Okay.
ahead, Attorney Chow.
All right, I just want us, on this issue of whether these are integrated or separate, and Mr. Hamilton makes much of the fact that, yes, we told DEP, maybe it's a common scheme of development, maybe it isn't. We brought it to DEP, we were transparent. By the way, I also did not use the word conspiracy. But in his submission, in his written submission to this board on page 5, he says the Tremont Board of Appeals lacks jurisdiction to entertain any arguments pertaining to the Acadia Wilderness Village. As such, AWL maintains a continuing objection to CTR improperly including any AWV arguments in this AWL appeal, as CTR must raise its arguments pertaining to AWV only in their currently pending Superior Court case and not before this board. And that's, so they want to have it both ways. This applicant wants to have it both ways. They want to integrate the project, but pretend they're not integrating the project. They want to object to any mention of AWL1 when there are very real impacts that AWL1 is going to have on AWL2 that because they were not transparent with the planning board, and I don't fault the planning board whatsoever on this, because they weren't transparent with the planning board on this. The planning board, let me finish, I'd never interrupted you. The planning board never got to even address the potential impacts that AWL, all of them, that AWL1 users would have on this site. That alone is clear error and is clearly contrary to the ordinance. And you won't find any findings that the standards could be met given those known impacts to this site.
Madam Chair,
Yes, go ahead.
if I could get in here for a second.
Okay.
I'd like to remind you and the board something that Mike said about something that was on the internet. This is an appellate hearing. So unless it's in the record somewhere, Mike, let's try to keep our remarks to stuff that's in the record, not stuff that's on the internet, okay? Secondly, Madam Chair, I'm looking at my clock here at 7:22, and I agree with Attorney Chow that she gets an opportunity, brief though it may be, brief, for some rebuttal. I don't know if you want to do that now or you want to wait till the next hearing. No, I'm asking the chair, not you, Amy.
No, I'd like to provide her that opportunity now. I'd like to actually, if we can, I'll check in with my board members. I'd like to get to the end of the public hearing and then decide whether or not we want to go further tonight or.
That's an excellent idea. Excellent.
So go ahead, Attorney Chow.
Thank you, Madam Chair, and I will keep my comments brief. I just wanted to address two main issues. One, since Mr. Hamilton raised the question of what is pending and what is an application and which version of the ordinance should apply here, and he cites law and years of experience in interpreting the law on this issue. And what I will first point out that he cites the Patanides case for the proposition that you can delegate decision-making authority of the planning board to someone like a city planner, and that you can authorize a condition of approval that does that. And the Patanides case, and I'm just going to quote it quickly. The issue was whether the planning board erred in issuing a conditional use permit with a condition that allowed the city planner to approve minor changes to the project plans. And in that case, the court said, there's no problem delegating minor changes to the city planner. This is actually exactly like the way your ordinance works with respect to minor changes to site plans. Those are the issues that were before you and are now before the Superior Court. And whether or not the code enforcement officer with respect to AWL 1 could authorize minor changes, or were they major? And your own ordinance says if the plans are major and not minor due to, if the changes are major and not minor due to field conditions, then you have to go to the planning board, because the planning board is the only body that can decide whether the standard has been met in the first place. So all of this case law that Mr. Hamilton talks about, I will submit to you, is irrelevant, because your own ordinance is clear. And the statute, if we're going to just for a moment talk about the law, 1 MRS 302, and I have a slide on this, which I'd be happy to provide my slide deck. I'm sure Mr. Hamilton could provide his to the board if you wish. But 1302 says, if your ordinance isn't clear, this statute provides a rule of construction, and there's a body of law built around this particular statute that fills in the gaps when your ordinance isn't clear. In this case, in your own ordinance, your ordinance is crystal clear. It says an application becomes pending only after you've done a completeness review. And whether there was a completeness review done in March, that doesn't matter. This, and whether you call this new or modified, this application was so different that all parties agreed, and the board agreed, that it needed to do a completeness review before it could continue. And the reason that's important, and the reason why there's a policy reason behind that, in this particular case, the voters in this town voted on May 5th to amend the ordinance to bring in campground changes that would improve standards for campgrounds. And the whole purpose of having an ordinance requirement that says, hey, you're pending if you require a completeness determination, is that if you change your plan significantly enough that you can comply with the ordinance that the voters have said you now should comply with, you should. There's no equitable reason why you should be grandfathered. You can comply. You're re-engineering this whole thing. You're rejiggering the whole thing, whether you call it a revision, a modification, a new plan. Your ordinance is clear, I would submit. And once it's clear, the 50-foot setback and other measures in that ordinance apply to this application, the application that was filed on September 14th and that underwent a completeness review. Now, secondly, I want to just for a moment turn to the issue of whether there was evidence of groundwater quality at the property line and whether you can delegate that authority. And as I already mentioned, Vitanides, Jake's, any of the cases that Mr. Hamilton has cited, I would submit to you he's citing improperly. This is not a minor change to decide whether groundwater quality has been met at the property line. It's the application has only this 300-foot standard, and that doesn't show anything about the property line. Despite what Mr. Hamilton says about there are mass balance calculations in the record, I have not found them in the 1,500 pages, and I think that Mr. Hamilton would have cited them if they were actually there. What's there is testimony that is far from evidence showing that there was groundwater quality at the property line. And instead what they did was say, and the reason I believe that the planning board adopted this standard is because they were getting pressure on November 1st to finalize approval on this. And so as a result of that, there was no evidence showing groundwater at the property line. And they said, well, we'll make them do a nitrate study in the future. And instead of bringing that back to the planning board for review and a determination, it gets sent to the code enforcement officer, who has to look at it, and he decides whether he's satisfied. And I would submit to you that that is an improper delegation of that authority, even if he files it with the planning board. So those are my comments on the two substantive issues. Thank you.
Thank you. Yes, Attorney Hamilton.
So there's a couple things that are going on here that I just need to correct. One is the notion that an ordinance provision that says if you've gone through completeness review, that's determinative under the law. Law court has been clear since the 1970s. It's when you start substantive review that you become a pending proceeding. And we got a completeness review in March 2021 of the campground. We then got a substantive review started as of April 27 of 2021. Attorney Chow entered this case on July 30th, and she's forward-looking from July 30th, but a lot of things happened before she entered the case. With respect to this conditioning authority, the cases rely upon what's in your ordinance. And I just want to bring to the board's attention, cite it so that you can jot down the citation and look at it for yourself. Article Roman numeral 8, section E2 of the land use ordinance says the following: the permitting authority may attach such restrictions or conditions as it deems necessary to ensure compliance. You have a groundwater quality protection standard that says you have to make a determination that will not only protect you at the time of the project review, but following development. I challenge even Attorney Chow to argue how you could do a study that would determine what you've got for groundwater quality following development at the time of an application review. You can't. And so all the board was doing was using the conditioning authority they have under their ordinance. You're right, CTR counsel, I really don't care in this regard what the case law says if there's a direct provision in the community's own ordinance, and there is. It's at Article 8, Section E2. Attach such restrictions or conditions as it deems necessary to ensure compliance. Anybody that knows Lawson Wilson, Mark Good, Brett Witham, know that they care deeply about the community. And they wanted to be sure that that requirement, that the standard review in Section M for groundwater quality protection was taken care of. Attorney Chow and I will never agree. I hasten to add that there was a lack of evidence concerning water quality and groundwater quality protection. There was an entire evening, October 26th, and no, October 26th is not November 1st. And yes, the board did have a second hearing on October 27th. So there was not a rush to judgment on water quality. That's just historically inaccurate. So I would like it if we could come back to the ordinance and if we could come up back to the facts of the project. We will be wide open. And this suggestion that we weren't transparent with the planning board, I've objected to it before. I just want a permanent objection for this record, that this applicant was anything but transparent. It won't matter how transparent we were. There's probably going to be claims that before the Board of Appeals, we weren't transparent. So I find it objectionable to suggest that the planning board didn't do their job because we weren't transparent. And so I'd ask you, Chair Harris, members of the board, please look to the record. We're stuck with a record. We all are stuck with a record. We're stuck with the findings. And our view is the planning board did its job and did its job thoroughly. As Ms. Hopkins said at the beginning, there was a very thorough scrub of this application. I think 28 hours says something, and it doesn't say rush to me. Sounds thorough to me. So If we could be relevant to the facts and relevant to the record, that would be helpful. I want to stop coming up with speculation as to what the planning board was doing or some theme or strategy that says you have to question what the planning board did. It's all right there in the record. You can find out for yourself. Thank you.
Thank you, James.
I just wanted to say that so that we don't get off base here, pursuant to the MMA manual, you go back and forth with these rebuttals. Usually it's the applicant who gets the last word. So I think we should cut Andy off. And maybe if Ms. Chow has a burning desire to respond to that, but we've got to cut off this argument back and forth, or those two will argue all night.
Here, here.
Okay. All right. So given that guidance, unless there is a question by a board member for either of the attorneys, I would turn the last word over to Attorney Chow.
Thank you, Madam Chair. I won't rehash. I'm mindful of the time, and I appreciate very much the board's attention and good questions on this. I will simply note, as my last slide indicated, that there are 7 or 8 reasons we have focused on, and any one of them, you could take alone or all of them, should result in the Board of Appeals reversing the decision of the planning board. And this is not an indictment of the planning board. I completely agree with Mr. Hamilton that the planning board was very thorough. They did the best they could. There was a huge volume of evidence and record that you're now all having to deal with. And the reason why we tried to keep our points to 7 or 8 is because these are ones that were clearly contrary to the ordinance. No one is ascribing ill motives here, but the reason that CTR felt a need to appeal is because we need to hold all applicants accountable to following the ordinance. And that is why we did that. And because there were errors, both substantively and procedurally, that resulted in a decision that was clearly contrary to the provisions of the ordinance, we think a reversal is certainly warranted here. I will just simply respond very quickly to the groundwater point that Mr. Hamilton mentioned. He said, well, how could you do a groundwater study showing that following development, you would have clean water at the property line? And I will submit to you, I agree with you, by the way, that I commend the reading of the October 26th meeting. There's a transcript and there's only several pages. And if you were to read it, what you would hear is that Matt Reynolds, CTR's expert, stated that it is quite common to do a nitrate study, which is a predictive study. It's a study that says, hey, based on this engineered system and based on the fact that maybe there's pre-treatment, we know what's coming out of the leach field. We know what nitrates are coming out of the leach field. And then we know how they're going to migrate across the property. And at the property line, is it going to be safe drinking water? That's exactly what a nitrate study does. It's a predictive study that says, if we assume a particular load on an engineered system, you don't have to do this after development, because if you've done it after development, you're too late. The whole point is the nitrate study is a predictive study based on inputs into the leach field after pretreatment and outputs that you get downstream, down gradient at the property line. And there is simply no evidence in the record that this standard was met. And therefore, the delegation of the authority of meeting that standard to the code enforcement officer was a mistake. And a clear error that all by itself should warrant a reversal in this case. Thank you very much for your time.
Okay, I want to thank both attorneys for their efforts to be brief. It is 7:38 by my calculation. Unless there's anything else, I would like to bring the public hearing portion of this meeting to a close, which I am doing. Okay, so now I'm talking to just the board members. I will entertain no comments other than from board members and from James. As I said, it's almost 7:45. What would you like to do? Do you want to, while this is all fresh, do you want to discuss it further? Would you like to sleep on it? We get back together as soon as possible. What's your pleasure?
I have a question, Chair Harris. There are 8 issues. Do we have to discuss all 8? Or if there's one that disqualifies the applicant, can we just decide on that one if that, how it works out?
My understanding is we have to decide on all 8. Is that correct, James?
Yeah.
Okay,
So that could, who knows how long that might take. But yes, we have to discuss all 8.
But Madam Chair, one
Yes,
thing you
James.
could do, if the board's feeling particularly ambitious, one way or another, to approve or deny quickly, is you could decide to take a vote on each one and then continue a temporary vote, it's called, and then continue to another meeting where a findings of fact, conclusions of law would be presented. Alternatively, you could also go through, and what I would suggest you do is see how many you can get through tonight. If you've got to go through all 7 or 8, whatever Mel said. And what I think the better thing for the board to do is to look at each one, get a motion, do the findings of fact, conclusions of law, then do the next one. I can write them up if you want me to do it or Jesse to do it. I kind of like doing them, and you can fiddle with the wording at another meeting. But if the board has its mind made up, you might be able to get through most of them. And then next meeting, we could just wrap up any loose ends and do the findings, fact, conclusions of law, and we'd be done.
Madam Chair,
Yes.
I am not ready. I am not enthusiastic one way or the other. I think that the attorney's presentations tonight have been excellent, have raised more questions in my mind. I want to check the record on a few other things. I think one of the problems that the planning board had was a self-imposed time limit. And I don't think we ought to be subject to the same problem. I think if we took a couple of weeks to become sure of where each of us wants to go, we'll make better decisions.
Mike or Marcia?
I know there have to be a number of days after we post the next meeting for when would be the earliest we could have it? Because I think both parties deserve an answer as quickly as we can reach one. But I agree with Rick. I'm all over the place right now.
Jesse, is it 2 weeks would be the quickest we could meet in order to give the public ample notice?
James, is there any, due to the fact they're continuing an already advertised meeting, do they have to follow the same timeline as far as
No.
posting?
No, you can just continue to a date certain.
Right.
However, Judge Cohen is talking about a couple of weeks. I'm not a board member. I'd like to do it like, have a rest and do it tomorrow. So it depends on what the board members want to do. If you continue to a date certain, the trouble with continuing to a date certain is the lawyers will usually whine and complain that their schedules are busy and so on. And unless you can get quick agreement, here you only have Amy and Andy, the Amy Andy show. Tempted to make a joke about that. but you only get the two of them to agree, and then you've got however many board members you've got. It's kind of like herding cats.
I still
Otherwise, what
think
you end up
making a
doing,
sound decision
I
counts
think
heavier than
avoid
that.
this is doing some sort of a doodle poll, which they do in Mount Desert, which is really like herding cats.
Well, it seems to me that Thursdays at 5 are a good time for this board. So, Jesse, if you would be so kind as to send out a doodle poll to the 5 members and to the other interested parties, that we will continue this when we can find a good Thursday to do it. I agree. The parties have been through a lot, and we want to get you an answer as soon as possible. I too want to reflect on what I've heard tonight and go back to the ordinances and some of the documents and review it. So I just don't.
Madam Chair,
Go
Madam
ahead, Mike.
Chair, since all the members of the board are here, why don't we just throw out the 14th and the 21st and get a show of hands of board members and whether those dates work with us, and then it becomes more a matter of can the attorneys accommodate those dates?
Okay.
I'll just add that the 21st is a conflicting date with another board committee meeting.
Okay.
So according to my calendar, the next available Thursdays would be April 14th and May 5th.
How many could make the 14th?
I have a problem. I can't tell you what it is. I can't remember, but I know I have a problem. I know my wife is listening to this stuff, so maybe she can sneak up in back of me and tell me, because I can't remember what time my problem is.
While we're waiting to find out what Rick's problem is, Marcia, could you do the 14th? You're on mute.
Did you mute?
I got it.
I'm told I have to mute myself.
It comes with being married.
I can do the
No,
I can do
it's
the
okay. She
14th.
tells, it's okay. I've got a morning appointment to get a car serviced. That's all it was. So I'm
All
fine
right,
on the
so-
14th.
So, Marcia, are you good for the 14th? I can't hear you. I still can't hear you.
Thumbs up.
Maybe you're. how
No,
about-
thumbs
is it-
up.
Can you do a thumbs up? Thumbs up or down? Oh, you can't do the 14th. Does anybody know sign language?
Only one.
I know she's saying something, but anyway, Mel, you can make it. Mike, you can make it. Rick can make it. I can make it. Marcia, you cannot, correct?
Maybe.
Maybe. Oh, I just heard maybe. Okay. So,
14th.
let's shoot for the 14th, Marcia. If you can make that maybe a yes, I'd really like to have you. Okay. So we're going to do the 14th at 5 o'clock. So anybody who's online and watched all of that unfold, feel free to join us then. And Jesse, you'll put out a link for us. Okay, once again, there will be no public input, but you're welcome to listen to our deliberations, and we should be able to provide answers in a week's time. I want to thank everybody for your cooperation, and I agree. I think the presentations were thorough and excellent, and you've given us a lot to think about. James.
I just want to wonder if it's a good idea to, as a courtesy, to check with Mr. Hamilton and Ms. Chow. I know they have huge teams at their offices, and Andy's got a more handsome son. He's much more handsome than he is. So we could have him, but
Andy seems to say it's okay. Attorney Chow, are you okay?
I do have a conflict, but I am gonna move heaven and earth to move it. So I think you should assume, I appreciate very much that you're dealing with multiple schedules here. I have a prior board meeting, but I'm gonna move it.
Thank you very much. All right. Then
Thank you,
we,
Amy. Thank you, members of the board. Appreciate it. The 14th works, can work fine for us.
Okay, great. All right, I want to thank you all. I'm going to munch on a sandwich here. Hope the rest of you get something to eat and have a good night. Again, I appreciate everybody's cooperation. Thank you very much.
Thank you very much.
And the meeting is
Bye-bye.
adjourned. Good night.